I very much appreciate Andrew's comments, I think that you point to a number of the sort of areas where the support is thinner than it might have been otherwise, but I still think that it holds up. With regard to going through an order, and generally, I think on incorporation by reference, I think we're pretty much agreed. With respect to insulation, I think that no other examples of express insulation come immediately to mind, though if I read the paper again, I would probably see references to one or two. But there are plenty of situations that we could think of implicit insulation, which I think if you're allowed to read a text sort of in the full and most natural way, is perfectly legitimate. So you might think that, for instance, the power of Congress to discipline non-members, if you think that the Rules of Proceedings Clause empowers each house to do the things that houses are allowed to do and to do them without interference by either a previous statute or any other government actor, then that is in some sense a textual hook for each house to use the powers that it has of punishing non-members or of holding them in contempt, without interference. In other situations, you might think that it's even more implicit than that. So for instance, if you're trying to figure out what evidentiary standard a court needs to use in order to strike something down as unconstitutional, whether it has to be clearly unconstitutional or just sort of when the court considers its best judgment, it's unconstitutional, whatever the rule is on that, you might think for sort of Plout versus Spendthrift Farm or U.S. v. Klein reasons that the vesting of the judicial power in the courts makes it very unlikely that Congress can come in and say, only strike down our laws under the First Amendment when you're really, really sure. Then that would be a form of insulation, even if the restriction on Congress is not explicitly made in the text. Moving on to the defeasibility points, where I think most of the issues come up. I'll fully recognize that defeasibility is slightly a different beast than, say, incorporation by reference or insulation by other parts of the Constitution, though I think that it's similar enough to be relevantly discussed together with the others. And sovereign immunity may be an example of this. Another example, which would be closer to your work, would be the question of whether various types of personal liberty rights guaranteed by the Constitution extend to enemy aliens, extend to people who are not U.S. citizens in other countries during wartime, sort of all the various conditions that might be imposed on them. You can imagine someone saying, well, the Due Process Clause doesn't say except in war. How on earth can you say, and doesn't say except if you're an enemy alien. How on earth can they actually be restricted? And one solution would be to say, well, it's just part of the meaning of what process is due, and sort of the words read in a historically sensitive way mean that. Or you could just say, no, this is a defeasible proposition. It was meant as a proposition of domestic municipal law that doesn't have any application to these various circumstances. And the reaction that somebody might have to that argument is, wow, the Fifth Amendment is not nearly as good as I thought it was. I really wanted an amendment that would stop Guantanamo. I really thought that's what we had. All of a sudden I found out through your ingenious historical reasoning that that's not the amendment we have, and that really upsets me. But the only way I can stop Congress from mistreating people in Guantanamo would then be to pass a constitutional amendment. So even though a full sort of translation of the Fifth Amendment in a way that is sort of fully adequate and historically sensitive might not say anything about wartime or enemy aliens, in the same way that a full account of what makes for contract formation could stop at offer, acceptance, and consideration and not mention capacity or the statute of frauds, those rules would still come in a way that is separate enough to say that that this is distinct from the meaning of the provision itself. And in fact, the limitation on the provision, the fact that the Due Process Clause doesn't apply in Guantanamo, say, is what's insulated from change. Unless the only way to fix that is a constitutional amendment. Doesn't mean we have to keep doing to people in Guantanamo what we're doing. Congress could always say, or the executive could always say, no, we're not going to do that, using their other powers. But the fact that they can is something we can't easily get around. Finally, this brings I mean, the next question that you have on can the common law or the law of nations be updated by courts? I think this is a really hard issue. I'm not sure I have any settled view on this, but I hope that the backdrops theory is agnostic as to it rather than being committed to one particular view. Certainly it's a harder backdrop if the courts can't change it either. And it seems plausible to me as a reading of the history that in fact, they didn't think that courts could make the law. They thought that their job was to declare it and not make it. But maybe that's wrong, and maybe the doctrine always was that courts were acting in a perfectly legitimate manner by deliberately changing the law to achieve better policy ends. If that's true, then I don't see any reason why backdrops can't evolve in the same way that the common law can, since backdrops really are just common law rules that have persisted over time. It really comes down to your view on how that's supposed to happen. Finally, with regard to the objections, as to the dead hand, I'm not sure that the cases of defeasibility are really all that much deader than the others. Certainly, I think incorporation by reference is not. If you choose to incorporate all the powers ordinarily incident to the executive, that was the choice you made. Even if you didn't know which ones those were, that was part of the risk that an actor took and deliberately chose to take. And similarly, for things like the rules on state borders, if you you could have decided to supply a code yourself, or you could say, look, we don't want to get into that. We're just going to leave whatever is there and prevent anyone else from monkeying around with it. That is a legitimate strategy for a democratically elected group to take. And finally, with respect to defeasibility, I think that there too, it's unreasonable to view it as meaningfully deader because it's always a choice what issues you want to get into and which ones you don't. So when Congress passes a new statute, they pass the live geese statute. They just don't want to get into the issue of duress. Maybe they didn't think of it. Maybe they made a conscious choice not to get into it. But it doesn't really matter in the sense that everyone knows that time is limited and certain things are and are not on the legislative agenda. So when a legislature enacts a statute and deals with certain problems, that is a choice, even if in some sense unintentional choice, it's a choice not to deal with other issues that were related that could have come up but didn't. And so in the same way that you might not say that adherence to all of the laws passed by the last Congress and before is democratically illegitimate because they're just things that the new Congress hasn't yet come around to re-endorsing. I think that would be a very strange view of what's democratically legitimate and what's at hand. I think in the same way, the rules that were sort of left in place that they decided not to do anything about are on the same level as the rules that they did decide to do something about. And with respect to unenumerated powers and rights, I think you're probably right that there are people for whom the attraction of originalism is writtenness, predictability, democratic legitimacy. I've never thought that those were the particularly strongest claims to be made for originalism, in part because I think that any theoretically coherent view of originalism will not necessarily lead to predictability or to democratic legitimacy. For one thing, with regard to predictability, if we passed a new amendment that said, it was the truth and justice clause and said, all laws have to consist with truth and justice, I don't know on what basis a court would have for ignoring that instruction, as long as we knew that it was intended to be applied by courts, but it would make things very unpredictable. And so in the same way that the response in my paper is not so much to convince someone who really cares about predictability that it will in fact be predictable. It's more part of the argument that that shouldn't be your test for whether something is part of the law.
Okay, our first troika is me, Larry Alexander, and Stanley Fish. My question is, do the backdrop rules include the rules of procedure or not? And if they do, then the common law carries with it the testimonial incapacity of the parties and the arcana of common law pleading. And if they don't, you're going to have an ahistorical conception of the rights that were understood at the founding because the framers didn't think about the relationship between substance and procedure the way we do. Larry.
I thought maybe you were asking me. First, Stephen, I really like the paper and the section on the feasibility in particular, and it's you know, to put this in terms of, you know, linguistic theory, it's very Gricean. You're basically setting up the sort of background by which, you know, that is presupposed in communication. So if the sign here says, you know, don't exit by this door, but there's a raging fire at the other doors, you know, we don't put in all of the context that gives meaning to this when we speak or write, and the same is true in the Constitution. So, and then some of the background assumptions are going to be dynamic in the sense that, you know, it's assumed that they might change, and some will be static, and, you know, it'll be a question of which one is we're dealing with. My question has to do with the mirror opposite here, which is the parts of the Constitution that have no backdrops. And so a few years ago, now it's many years ago, it's in the Clinton administration, a colleague and I wrote a little article attacking a Supreme Court opinion, which is completely unremarkable, except that this was a 9-0 opinion, and you know, pretty curt, not, you know, and but it turned on it was the base closing issue, and Clinton was alleged to have gone around the procedure that was set up for the base closing. And the court ruled that the suit couldn't be, that there was immunity, that the president had immunity. Of course, this wasn't a monetary suit, but the president had immunity if he was alleged to have acted illegally, which he was alleged to have acted. But not, he does not have immunity if he's alleged to have acted unconstitutionally. So we got to thinking, well, give us an example where the president, who derives all his powers, presumably they're either from the Article 2 or you know, from Congress. So what's an example where he acts illegally, but not unconstitutionally? And we couldn't think of any. The president seemed to us to be something that was created by the Constitution. So he's either got these powers from the Constitution or he's got them from law. And if he's violating the law and he doesn't have an independent constitutional power, then he must be acting unconstitutionally. At least he's either not acting unconstitutionally or he's not the president. He's you know, he's William Jefferson Clinton, but he's not the president. So one thing you might think about doing here is just sort of, you know, contrasting constitutional backdrops with those parts of the Constitution that have no backdrops, where if it isn't in the Constitution, it doesn't exist.
Stanley.
Yeah, I wanted to ask a question which I hope would clarify the claims, Steve, that you're making in the paper. And it has to do with exactly what a backdrop's approach is. And my emphasis will be finally on the word approaches, or approach rather. You gave an account at one point when you said that when the text runs out, then you might have recourse to the kinds of backdrops that you catalog in the paper. And I would offer an emendation, or in my mind, a correction of that, because it seems to me that what you're calling the backdrops are always in place, and that it is within backdrops that texts emerge, and are readable and are debatable. That is, you can have controversies about them, so that backdrops are always there. So that for your word backdrops, I might substitute a couple of familiar, and for also your phrase, what is silent, I might substitute a couple of equally familiar phrases, the category of what is taken for granted, or the category of, even better, I suppose, for our purposes, category of what goes without saying. What goes without saying. Now, the category of what goes without saying is always in place in order so that both thought, i.e. intention, and interpretation can occur. And in fact, it's within the category of what goes without saying that even a single word's meaning and the meaning both that an author might have had and the way in which it might be understood is specified. So if that's all true, then I think that it may be too modest a statement to say, as you said, that there are many, many areas within which the question of backdrops could be raised. I would say it's all areas necessarily a question of that the issue of backdrops does arise. And so I would end by asking a question to which I would give a negative answer. Can there be a non-backgrounds approach?
Thank you to the three of you. I first say, with respect to procedure, things like testimonial capacity, I don't think that those would be backdrops, and the reason would be that, or rather it would depend on what rule you are relying on to insulate them from various aspects of change. So for instance, it might well be that First Amendment suits look very different once we get rid of testimonial incapacity, or in particular, sort of maybe the shape of the confrontation clause depends heavily on what we think hearsay rules are, and maybe changes to hearsay rules can do things that really undermine the confrontation clause, but aren't in fact barred by it. And I would say that whatever story you tell for why that is, why that's problematic would have to go even further and say it's so problematic that it's actually barred. And I'm not sure that that's always necessarily true. So it might be that by passing the federal rules of civil procedure, by enacting new equity rules, Congress can change the procedural structures through which rights will be enforced, but it requires further argument to claim that the procedures are therefore in some sense hard-coded by the rights, or at least guaranteed by the rights, and that perhaps to some extent sort of procedures that make it impossible to make use of the rights would be barred, but you'd have to have an account of how that comes about as well. With regard to Larry's question about so the president acting illegally versus unconstitutionally, I think one of the ways in which I've tried to pursue this problem is to try and deflate the hierarchy that's sometimes put in between sort of constitutional law and the rest of the law. The Constitution isn't sort of more law than other parts of the law. It's just higher law. It just trumps things that would be inconsistent with it. So when the president acts illegally, that's just as bad as violating the Constitution, because the Constitution is just part of the law. And so I think I would agree with you. I think that it would be hard. Furthermore, there's a take care clause, which includes a constitutional duty to obey the laws. And so that would be further problematic. But I think that in areas where there is no sort of way to get around the legal provision, that in area, or let me rephrase that. In areas where there is law that needs to be followed, and that could be international law, depending on your theory, it could be common law, all actors are obligated to follow that law as much as anything else. And so it would be, I think, particularly problematic to say that the president is immune in some cases, but not in others. And finally, with regard to Stanley's question about sort of, are we really talking about what happens when the text runs out, or are we saying what always has to happen in order for us to understand text, or in order for us to text sort of do the function that it's supposed to do? I definitely think that it's true that that meaning sort of arises from those kinds of contextual comparisons, that it depends on what's taken for granted to properly understand what was in fact said. But I think that it's useful to highlight a particular subset of those areas. So, take, for instance, the state borders cases. There's a very different move between saying that, the ex post facto clause derives from contemporary usages. It depends on linguistic context and legal context. It has a certain meaning that applies to, criminal but not civil. And then moving from that to say, and therefore you can't punish someone for having gambled in Virginia in 1785. Because that fact is true because of history, but in a very different way then the correct reading of the text is true because of history. And that's the distinction I'm trying to get at, though I may not express it perfectly throughout.
Our next triad is Mike Ramsey, Ilya Solman, and Jamal Green. Mike.
Well, I like this paper a lot too, and I buy into the idea of the constitutional backdrops. I like that idea, but what I want to suggest maybe is that there are not as many of them as you see, or maybe to put the question a little bit of a different way, I'm not sure what quite follows from calling something a backdrop as opposed to what I might be inclined to call it just an interpretation of the text, giving it accord to its historical context. So just a couple of examples. I actually really like what you said right at the end about the scope of habeas and the scope of the Fifth Amendment, which I think is perhaps a good example, though I'll touch on a couple others real quick. But the question of whether habeas has an application extraterritorially, it seems to me, can be got at quite directly by the definition of habeas, and then you ask what did the writ of habeas corpus mean at that time, and if you conclude that it did not mean a procedure that was available overseas, then that's just an interpretation of what the text is referring to, the right that the text is referring to. On the other hand, I do think that the scope of the Fifth Amendment is a good example for what you're looking at, and if you conclude that the Fifth Amendment was sort of assumed, and maybe I think of these as assumptions rather than backdrops. If it was assumed not to have application overseas, at least to non-citizens, then there really isn't any way you can call that interpreting the word, finding. You're not looking at a definition of words there. You're looking instead at an assumption that sort of comes before the words. And I think that's what you're trying to get at. It's just I don't see it in as many places. So let me just quickly give two others where, on the removal of executive officers, again, I see that very much as just a question of what does the executive power mean? You're not asking about something that's an assumption underlying the grant of executive power, but instead you're asking directly what is encompassed within the phrase executive power, and that seems to be just a textual question. It's not a plain meaning. It's something that requires going into the context, but it certainly involves looking at the way the phrase executive power was used at the time and what that encompassed and did not encompass. In contrast to the question of whether the Fifth Amendment would apply to non-citizens overseas, which doesn't seem to me to involve asking anything about the way the words of the Fifth Amendment had historically been used. It instead is asking something about an assumption about the scope of sovereign power and sovereign limits that is not embedded within the Fifth Amendment, but that stands behind it. And then my final point I wanted to ask about is the state borders question, which it's a great conundrum, but I'm not sure it's an example either of what you're talking about, because in asking the judiciary to undertake the job of adjudicating state borders, the Constitution, assuming the Constitution did that, the Constitution actually was not referring to an antecedent historical practice. The idea that a court would adjudicate sovereign borders was a new idea. It was an innovation of the Constitution, and again, it seems to me that if you're going to get that, you're going to get it out of an interpretation of text, specifically the Article 3 grant of jurisdiction to courts over these kind of controversies, coupled with no standard by which courts could no explicit standard by which courts could judge them. But so I don't think a number of these examples sort of I'm maybe without more I don't see them as examples of what you're talking about. But I do very much get the concept. So I'm not sure if that's if I'm off, but I wanted to sort of put that out there and see what you thought of it.
Yeah, so I think there's a lot of things I agree with in the paper. I, in some ways, kind of agree with Stanley Fish that, in some respects, any text that you have, there's going to be some background assumptions that necessarily are not in the text itself, because we can't understand a text at all unless there's sort of some background understandings of what it refers to, which may, in this case, include things like pre-existing law and the like. At the same time, I have a couple of reservations, although I'm not sure how important they're going to be in terms of sort of particular constitutional provision that you're interpreting, though I do think they have application to your approach to the 11th Amendment. One is that your paper seems to be perhaps unintentionally situated in this long-standing debate about the nature of the American Revolution, the founding, between some people on the one who say, well, it's just sort of a Burkean thing that's leaving pre-existing tradition mostly in place and just making a few little innovations at the margin, and others who think that, no, this is actually a novus ordo seclorum, a new order for the ages, a new big change. And I think, you know, obviously there's serious people on both sides of this debate, but I think there's a lot of evidence suggesting that in some respects, at least, it was more radical than you're giving it credit for. Gordon Wood's book, The Radicalism of the American Revolution, I think is very compelling on this, and certainly, at least in a couple ways, it was a big innovation. One is it's a new form of government, sort of Republican federalism over a large territory, right, which had never really been done before, and the Federalist Papers just refers to it. Second, it's the first government based on the sort of the ideology of liberal or Lockean republicanism, and that's sort of a pretty radical compared to standard of the 18th century. And I don't want to push this too far. It's true, it's not like the Khmer Rouge in Cambodia saying this is year zero and everything is swept away and we're going to kill millions of people who we don't like and who don't agree with us. But it's not as radical as that, but it may be more radical than you're giving credit for, and therefore maybe you may too readily assume that it just leaves in place everything except for a few isolated islands, islands of stuff which it changes. This thing has particular force with reference to the 11th Amendment because the whole background to the 11th Amendment that people were citing was the idea that, well, how can you sue the sovereign without his consent under the law? Because after all, the sovereign, the king in European countries, is the source to the law. It doesn't really make any sense to be able to sue him. But in a sort of context of republicanism or democracy where the people are the ultimate source to the law, it makes perfect sense to be able to sue the sovereign. And I think at least some people in the founding generation made this very point. You see this in the debates in this sovereign immunity cases. I remember when I was in law school, actually, at Yale, I remember Bruce Ackerman saying in class, well, sovereign immunity is really just a form of barbarism that the American Revolution rejected. Don't know if I would go quite as far as he did, but there's some merit to his view. Secondly, and closely related to that, I think it's one thing to say that sort of there's a backdrops that fill in the text or sort of help us deal with ambiguities in it. It's another thing to make the claim that there are these backdrops that in effect sort of constrain what otherwise seems like the plain meaning of the text. So again, the 11th Amendment is very relevant here. So not especially the 11th Amendment, the sovereign immunity. It seems like the judicial power of the United States extends to all cases arising under the Constitution, not merely those where the state is not a defendant, right? Similarly, Congress's Article 3 powers seem to extend to say all cases where they're regulating commerce, not merely cases where they're regulating commerce in a way that doesn't involve suing a state government. And I can make a similar point with respect to other enumerated powers. So it may be the case that sort of the original understanding of all those texts was just that they sort of implicitly intuited that exception, although as Chisholm versus Georgia shows, by no means everybody actually thought that. But it seems to me that when you're saying that this is a carve-out to the plain meaning of the text, or at the very least the burden of proof for this kind of backdrop argument is going to have to be higher, especially when you combine it with my first point that this is a new form of government based on in some ways a new ideology, and therefore there's a lot of sort of pre-existing stuff that, to apply Ackerman's terminology, they may have rejected as kind of barbaric and retrograde and wanted to get rid of. How this applies to particular parts of the Constitution, it will vary from case to case. And maybe every single one of your conclusions can still be defended in light of this, even maybe the sovereign immunity thing. But I think it maybe need to take a little bit more account of these things than maybe the paper does so far.
I also, as I said to you before, really like this paper. I also agree with what Ilya just said. But I wanted to raise a a candidate for a constitutional backdrop that I think is fairly clear from, or fairly obvious from your text, which is rules of proportionality when rights are violated. So, which is sort of the equivalent of an affirmative defense for a state for violating a right. So, the basic general rule being, states can overcome rights violations if they have good police power reasons for doing so. Let's say that. So you can think about whether you think that's a backdrop or not. Right? A country like Canada puts that in the text of the Charter of Rights and Freedoms. We don't, but we assume that exists. I think thinking of that as a backdrop illuminates at least a couple of problems in constitutional law. One being the sort of debate between Justice Black and much of the rest of the court about whether the First Amendment or whether free speech is absolute. Right, we can recharacterize that as Black taking the Mike Ramsey position, which is this is all textual interpretation, and the rest of the court saying, well, no, that there's a backdrop that we have to keep in mind here. The other example, which is maybe this even illuminates more, is City of Bernie versus Flores, in which we can actually think of that case as not as being distinct from a case like Morrison, for example, where what Congress did there is not change the right, but change the backdrop. Right? They didn't say that there's some religious freedom right that didn't exist before. They just changed the proportionality rules that apply. And so, so I think that thinking about this in backdrops makes at least me think about both those problems in a slightly different way. It would be more illuminating to me if I could then translate that into some normative proposition about what to do about these cases, which I don't quite have from the paper yet. And this is part of Andrew's point, I gather, which is I mean, it's a complete paper in itself, and this is maybe another paper, but saying more about what the legitimacy of legal change for different kinds of backdrops would be very helpful. So, for example, if we call what I've called the proportionality rules a backdrop, right? They have changed over time, and as a general matter, they've changed from states can violate rights if they have good police power reasons, to states can violate rights if they have really good police power reasons, right? Lochner era may be a different rule than the current one, but that changes through constitutional common law. It doesn't change through a constitutional amendment, even if the 14th Amendment may have been understood against a different constitutional backdrop. And so, so one wonders, well, what's the legitimacy of that? And then second, in the City of Bernie context, right, Congress is changing a backdrop. How do we think about that normatively? Is something that I don't have an answer to from your paper, but it does help to illuminate these problems and make me think about them very differently.
Thank you. There's a lot there between the three of you, so I hope that I'll be able to respond to the points that were made, but I apologize if I forget anything, and please feel free to come up to me afterwards. Starting with Mike Ramsey's question, sort of how are backdrops different from interpretations of the text? So I'm glad that you sort of accept the distinction with respect to the Fifth Amendment. There's sort of something different, at least, going on between looking at sort of the meanings of words and having the sense that there are sort of limitations on them that are the result of the application of other doctrines of law. But I think that there are more cases where what's really going on is not meaning. And obviously this will come down to a whole lot of sort of small bore interpretive debates over particular provisions, but I think that this is right. So take, for instance, the writ of habeas corpus. It might have been a rule that habeas writs were not supposed to issue outside the territorial jurisdiction of a court. But the way that would have been understood, perhaps, and I don't know the history, and this would be a historical question, is not because they thought that writs that went beyond those limits weren't writs of habeas corpus, that using that language to describe them was somehow a category mistake, but just that, no, that violates the rule that you're not allowed to send them outside your territorial jurisdiction. No one would be surprised at calling that a writ of habeas corpus. The definition of writ of habeas corpus could usefully apply to such a thing. It's just that there's this other rule that you're not supposed to do that in particular cases. In the same way, you could think of executive power as just being synonymous with a whole long list of powers that the executive has, such that if they had spelled out that entire list in the Constitution, there would have been no change in meaning. I argue that that's not quite true, and drawing hopefully accurately on Chris Green's work, that there's a difference between what kinds of phrases would be synonymous with each other and what kind would have the same legal consequences. So it could be that it would, for instance, it's synonymous with the ex post facto clause to say sort of no retrospective criminal legislation, but it's not synonymous to say no punishing gambling in Virginia prior to June 7th, 1975, when they finally outlawed it, and et cetera, et cetera. So the very long list of those things. I cash out the difference between these two pictures to some extent in the discussion of the appropriations clause and the 2-year limit on Army appropriations that doesn't exist for Navy appropriations. It's not the same thing to say that sort of an undetermined term is part of the meaning of the power to raise, to provide for navies. It's just another rule that normally applies and that might be cut off. So the Army clause isn't self-contradictory, where it creates a power to raise armies and then puts a 2-year limit on appropriations. Why does this matter? I think the reason it matters is because the types of evidence we're going to be looking for will be different. So if you wanted to know whether removal was an executive power, was a power incident to the executive, the kinds of sources that are going to tell you that are not quite the same sources as will tell you what the meaning of the phrase executive power was. Sort of, if you describe, you can imagine, someone describing executive power in a state that doesn't have removal, or removal power in the executive, or saying in France the executive power is vested in X, even though they don't actually have removal power the way we do. And the phrase could still be meaningfully used there, would still have the exact same meaning. It's just that the things that it would refer to might be different. Similarly, with regard to state borders, I'm not sure that having adjudication was a completely new idea. I mean, the Articles of Confederation have this sort of bizarre jerry-rigged arbitration committee to decide state border problems. But certainly the idea was that there was a group that would quasi-judicially decide it. I mean, they have taken oath to decide it well and truly without fear and favor, et cetera. So they're acting like judges when they do it. But I think that even the delegation and the absence of a standard doesn't mean that pre-existing rules come in as part of the meaning of that text. They're not sort of baked into the delegation without a standard. It's more that when you have a delegation and you don't have a standard, well, what are you supposed to do? You apply whatever else is on the table. So that there's sort of a second step in the analysis. You first figure out the meaning that, okay, we know from the text that we've been delegated judicial power to decide this. Now we have to figure out what to do, and to that we're not looking to the text to answer it. We're looking to just ordinarily applicable law. Next, on to Ilya's questions. I think it's true that you can't understand the text unless you know where it comes from. I feel like that that is the essence of the sort of ex post facto example, trying to draw out exactly when are we looking to where it comes from for the purpose of knowing what the text means, and when are we looking at it to determine sort of the facts that it tells us to apply. So when are there external sources that it points us to? The example here would be my Fermat's last theorem example. If you have if the amendment said juries shall have 6 people unless Fermat's last theorem is true, in which case 12. We need context to know exactly what mathematical theorem they were talking about, but knowing whether it's true or false is not part of the context. That's just a fact that we have to find out. And it might be a historical fact. It might be, depending on what we're being told to go look for. But it's separate from the activity of interpreting the text. As to whether sort of the American Revolution creates a new world order, I think in certain ways it clearly did. If you look at sort of the common law reception statutes the state passed, all of them talk about sort of we bring in the English common law to the extent it is suitable for sort of our new arrangements. And I think that the proper meaning of that is actually, and this was a general idea, I mean, the quote from Marshall here is that even had they not passed that, I would assume that would have happened anyway. But the assumption there, I think, is that suitable has a very narrow meaning. I mean, they mean things like we don't have a king, we don't have parliament, certain doctrines that would, we don't have feudalism, certain doctrines that only make sense in that context don't apply here. But it doesn't mean that sort of the very vast bulk of legal rules is in some way upended or needs particular justification to keep operating. So if people if I owned a house in Virginia before the Revolution, I still owned it after the Revolution, even though the English common law is not sort of valid by virtue of our still being part of England. my entitlement to that house continues because they had doctrines that revolutions might change certain aspects of public law, but typically left a lot of other law alone. And there's discussions of how when you take property by conquest, you don't upend all of the legal relations that are already present within that property. You just sort of leave those there until the new authority does something to affirmatively change them. And I think that those rules can be relied on pretty effectively. So then there's a question, though, where does sovereign immunity fit in that? There's a perfectly good argument that says, look, sovereign immunity was one of those things that was suitable to the king and isn't suitable to a republic. And people made that argument, and it got a majority, or I don't know that that argument got a majority in Chisholm, but certainly it was made in Chisholm, and it was made on the side of the majority. But on the other hand, an awful lot of people seem to think that that wasn't the case, that the that the states retained certain aspects of sovereignty, one of which was sovereign immunity, and the comments in the ratification debates may bear that out. And certainly the fact that the 11th Amendment was passed so quickly may give some indication that it wasn't regarded as barbaric by a sufficient number of people. Finally, with respect to the issue of proportionality and whether states can override rights so long as they have good reasons to do so, that Jamal raised. I think that there are two things to say here. One is that it's possible that some of the amendments ought to be read in backdroppy ways, such as by incorporations by reference. So for instance, if you read the Brown versus Entertainment Merchants of Video Games case and U.S. v. Stevens, the Animal Crush video case, they make noises about how the First Amendment codifies the freedom of speech. That refers to a particular freedom existent at the founding that had certain limits already inside it, namely limits for obscenity, limits for libel, et cetera, et cetera. Those limits stick around not because they're sort of mentioned in the text or part of the meaning of the words freedom of and speech, but just because they were part of the freedom that actually was incorporated by reference. So those kinds of exceptions certainly stick around in a backdroppy way. The further question of whether there's a more general defeasibility principle here, such as proportionality, I honestly don't know. I would think that would have to be answered by looking to the historical sources. My guess is no, in part because most people have not thought that, so the way that states having very good reasons have come in has sort of been a legacy of strict scrutiny and the various tiers of scrutiny that have been applied, as opposed to some general sense that sort of states get to trump individual protections when it's really important to do so. But maybe that's not true. Maybe my sense of that historically is totally off base, and that would just depend on what the answer were there. And then with respect to Bernie, can you change the backdrop? I think that's a really interesting question. I mean, I think that if there are principles that can come in and defeat rights when it's really important that they be defeated, and it might very well be within Congress's power, it might very well be appropriate to the execution of the protection of individuals and their privileges and immunities from state interference, that that backdrop be limited in certain ways. So it might fall under Congress's power. I just don't know.
I'm willing to extend the hunting season, but only for rifles, not for shotguns. With that qualification, we have Kurt Lash, Chris Green, and John McGinnis for closing shots.
I really enjoyed it. I like the idea of tax drops. I also like the fact that I think this fits very well with Jennifer's paper, because both are kind of talking about the legal soup in which a text is actually adopted, and that it can, understanding that backdrop can change how we approach that particular text. And that makes me think of the 60-40 problem. I don't think the 60-40 problem is a problem for originalism. I think that originalism introduces the 60-40 problem if it's done correctly. In other words, it brings new historical evidence, a new historical context to bear in a way that challenges our assumptions about what maybe the consensus might have been or might not have been. It might challenge our ideas about what Article 3 allows or doesn't allow, might challenge our consensus about McCulloch and how McCulloch might actually function under the 14th Amendment. So I think it does that job admirably, and I think it's a wonderful paper. My brief question is simply, does it matter whether or not people know the backdrop is there? If they don't know it's there, then what kind of normative argument can you make that would allow an unknown backdrop to operate as a constraint in terms of diffusibility? If they do know it's there, then doesn't that then affect the actual meaning of the text?
Right.
Chris?
Try to be as rifle-like as possible. 321, just all the judicial power, except arising under these controversies. How are we going to resolve them? You can go through all of these. I think there's probably 6 or 7 different examples of things that are insulated from change. Land grants from different states. How are you supposed to resolve them? It seems like you got backgrounds. 432. Nothing in this Constitution shall be construed to prejudice any claims of the United States. You got this claim, the claims of a particular state. 6.1, all debts that are already been entered into shall be as valid under this Constitution as under the Confederation. Almost every place in the Bill of Rights that uses the word "the," right? There's dozens of these. So. I love the Randolph citation. So Scalia, at times, seems to understand the sense-reference distinction. And you certainly do.
John?
Well, I really like this paper. Jamal and Stanley have somewhat preempted my question. So I might just step back and make an observation about how I think this kind of enterprise is so essential to originalism. What I see this at the highest level as doing is underscoring the point that the creation of the Constitution is not a creatio ex nihilo. It is a legal document that is a portion of a much larger legal regime. And what does that mean? Well, first of all, it emphasizes it's a legal document that has to be understood according to legal rules. But more importantly, it helps us understand how it is a practical enterprise. One of your important points is that there's no reason to believe that it destroys the existing doctrine of precedent, which is, in some sense, the huge problem for originalism. If it does that, originalism becomes a pitiful, helpless giant. It becomes irrelevant. And I think understanding the document in this way. And then the other point is, it just gives a lot more information and resources. One odd problem I always get when I say I'm an originalist at cocktail parties is, well, how do you actually decide all these cases? How do you decide all the cases? This is a little document. But by putting this in a larger legal regime, you bring a lot more information. And just to go back to Jamal's point, in some sense, the compelling interest standard, I think, goes back to Bologna, when they said, of course, that drawing blood on the streets by a surgeon didn't violate the statute there, and by putting it,
Slicing the bologna.
putting that in that mechanism of the West brings us all of this information and makes originalism much more both practical and powerful. And so I thought it was just a great article.
I don't know if you're at cocktail parties.
We were an hour after we started. So I might, the last comments were charitable enough that if you would waive rebuttal, we could adjourn.
I certainly wouldn't keep you guys, but I'd be happy to talk to all of you or some of you about what I think about these things.
Let's thank our speaker.